Are evictions now allowed under Alert Level 1? Hi, I'm Simon Dippenaar and I'm a family lawyer. There's been a lot of confusion surrounding evictions. What is allowed now that we are in Alert Level 1? In the early stages of the national state of disaster, evictions were prohibited. As hard lockdown gave way to gradually lessening restrictions, the status of eviction orders also changed. For a while, eviction orders could be granted but not executed except in extreme circumstances. A recent case that resulted in a successful eviction has given us much more insight into what the courts consider to be fair or just and equitable in law. It also makes it clear that there are a certain time frame that must be respected before the court will order the sheriff to physically evict the tenant. While rental housing legislation protects tenants from unfair treatment by landlords, owners also have the right to use and enjoy their property. They must be allowed to evict a tenant who is illegally occupying premises. The case of Philander versus McKitt in the Western Cape High Court was a significant watershed. The judgment clearly explains the factors the judges considered in granting the eviction order and what conditions must be present in the current environment. In determining justness and equality, the court stressed that all relevant circumstances should be considered. The judgment states, among those circumstances, the availability of alternative land and the rights and needs of people falling into specific vulnerable groups are singled out for consideration. In this case, the tenant was a 19-year-old male with no dependents whose family lived nearby. The availability of alternative accommodation is a key consideration, along with the time frame given for the tenant to vacate. It must be reasonable, not only for the tenant, but also for the property owner. The judgment also states, what date would be just and equitable upon which the eviction order should take effect? Once again, the date that it determines must be one that is just and equitable to all parties, unquote. In Philander versus McKitt, the tenant was originally given the notice to vacate the property legally more than 18 months earlier. There was ample time to find alternative accommodation. As the tenants did not cooperate and in light of a wide range of circumstances, the court awarded eviction from the premises to take effect by 31 October. This gave the tenant more than a month to move out, and this case demonstrates that the courts will grant an eviction order under Alert Level 1. If you are a landlord, you must prove that your eviction is just and equitable. The illegal occupancy of the premises is not the only factor the court will look at. The tenant must have alternative accommodation. Courts need to know that tenants will not be left destitute and without shelter. You can anticipate this by requiring your tenant to provide an alternative accommodation address in the lease agreement. This will ensure they have a viable option should you need to terminate the lease, and the court will be assured of the tenant's security if you have to apply for an eviction order. If you are seeking an eviction, we can help you construct your case to meet the court's requirements based on recent case decisions and secure a successful eviction order. We can also help you with your lease agreement. Call me on 086 099 5146 and let's chat.